After Musk's loss, OpenAI's watchdogs look pretty thin, and today we finally have names on the short list. This is Musk v. Altman daily. We're closing out verdict week, and the story's moved from who won in court to who actually has enforcement power over OpenAI's nonprofit mission. CalMatters put together a roster, and it's shorter than you'd hope.
California AG, Delaware AG, the IRS, the board, and one of those is literally OpenAI's own board. Also, Greg Brockman's sitting on a reported $30 billion personal stake while testifying about the long road to for-profit. Busy Friday.
The Ringer's post-trial breakdown is also trying to answer what survives from Musk's case without a merits ruling. And the answer is not nothing, which is where we start.
Okay, so the jury said Musk waited too long to sue. That's just standing, right? So who actually has the authority to hold OpenAI to its original nonprofit mission if he's out?
Great question. The honest answer is a short list, and there are some real gaps in it. The most direct legal authority sits with state attorneys general. California AG Rob Bonta and Delaware AG Kathy Jennings both spent more than a year reviewing OpenAI's restructuring, and Jennings issued a statement of no objection to the conversion in October 2025, which effectively blessed it. Bonta signed off on the for-profit transformation too. But critics told CalMatters almost immediately that the deal was, quote, full of holes, especially because it leaves open ways OpenAI could still capture value built under its charitable roots. Then there's the IRS, which reviews OpenAI's annual disclosure forms, and a researcher looking at the latest one noticed OpenAI had quietly dropped the word safely from its mission statement, per reporting in the Chronicle of Philanthropy. The IRS can revoke tax-exempt status, but it rarely polices mission drift in real time. The board is the internal check, but the restructuring the AGs reviewed also reduced the nonprofit's oversight role over the for-profit subsidiary. So in practice, you've got state AGs with real but episodic power, an IRS that moves slowly, and a board whose leverage was deliberately narrowed.
So the two AGs already looked at this and said, fine. Does that mean that lane is basically burned? Or can they come back if something new goes wrong later?
Attorneys general can reopen investigations if new conduct warrants it. Their sign-off on the restructuring wasn't permanent immunity. But the critics' point is that the framework they approved may have locked in structural weaknesses that are now very hard to unwind, even if someone comes back later. What matters is whether the nonprofit still has meaningful control over the for-profit in practice, not just on paper. That's the fault line experts flagged the moment the deal was announced. Nilay Patel, writing in The Verge,
after nearly a month, with the trial featuring testimony from Musk, Altman, Microsoft CEO Satya Nadella, OpenAI co-founder Greg Brockman, former OpenAI board member and mother of several of Musk's children, Siobhan Zilis, and a few others, the jury deliberated for a couple of hours before returning to the room full of untrustworthy, unreliable people all fighting with each other with a verdict, deciding to dismiss all charges due to the statute of limitations.
The Verge's running update page is basically the trial's table of contents now. But what it gives us today is the cast list. Musk, Altman, Nadella, Brockman, Zilis, a jury that deliberated a couple hours, and a dismissal on statute of limitations grounds. That's the procedural obituary. The governance question is still alive, and CalMatters is the first outlet today to actually name who's supposed to answer it. California AG Rob Bonta, Delaware AG Kathy Jennings, the IRS, the board.
And that list looked a lot more reassuring before you remembered Bonta's office has already been reviewing this restructuring for over a year, and OpenAI is still rewriting its own rules. So the cavalry's been on the field, just not charging.
That's the escalation this week earned. Monday was, the mission question survived the verdict. Today it's, here are 4 specific actors who theoretically hold the mission question. And here's exactly why each lane is harder than it looks. That's not uncertainty anymore. That's closer to an indictment of the oversight architecture itself. Here's Katie Baker at The Ringer.
The jury's ruling was directionally very bad for Musk. but plenty from his case against Altman and OpenAI will endure. Let's break down the key takeaways from the courthouse in Oakland.
The Ringer's Katie Baker has the cleanest post-mortem we've seen this week. Her frame is directionally very bad for Musk, but plenty will endure. And that's the tension worth pulling apart today. Not what the jury decided, but what's now sitting in the public record with no verdict attached to it.
Satya Nadella said amateur city on the stand under oath about OpenAI. And that quote just lives there now. No verdict, no ruling, just a Microsoft CEO's sworn characterization of his biggest AI partner floating around.
Which is exactly the IPO disclosure problem Fareeda Khalaf flagged earlier this week. The Ringer is the first outlet to really try answering what the trial record leaves behind for someone reading a registration statement. The answer isn't a precedent, it's a paper trail.
A paper trail with no judge's signature on it. That's what I keep coming back to. 3 weeks of testimony, 20-plus witnesses, a professional futurist Musk once called a jackass, and the S1 just has to disclose that no court ever said the structure was sound.
Crypto Briefing writes,
When OpenAI launched in December 2015, the pitch was simple. Build artificial general intelligence safely, make it benefit humanity, and do it all as a nonprofit. A decade later, co-founder Greg Brockman sits on a personal stake worth roughly $30 billion in what is now a Delaware public benefit corporation.
Crypto Briefing puts a number on it this morning. Greg Brockman's personal stake in what used to be a nonprofit is now worth roughly $30 billion. That figure is sitting right next to his 2018 and 2019 diary entries in the court record. And no jury ever ruled on what it means.
He's out there testifying about the long road from nonprofit to for-profit. That's a rich framing when the destination includes $30 billion in your personal column. I want to know, at what point on that long road did the compute problem start looking a lot like an equity problem?
That's actually the unjust enrichment theory, and it's still unresolved. The jury never weighed those diary entries against that stake. What's new today is the number itself is finally public on the record, which changes how you read the S1 governance disclosure question we've been carrying all week. If you like staying ahead of fast-moving, high-stakes stories, try Ebola Watch, a daily DRC and Uganda Ebola outbreak briefing covering case counts, border tracing, WHO vaccine news, and traveler guidance. Find it wherever you listen to podcasts. You'll find links to every story we covered today in the show notes. So if one caught your ear, you can dig into the source material there. That's Musk v. Altman Daily for this Friday. This is a Lantern podcast.